May I now invite the Honorable dignitaries onto the dais. Honorable Mr. Justice P.S.Narasimha, Judge, Supreme Court of India. Honorable Mr. Justice Ashish Jitendra Desai, Honorable Chief Justice of Kerala. Honorable Mr. R. Venkataramani, Attorney General for India. President, Krishna Iyer Foundation for Law and Justice, and Adv.Sanand Ramakrishnan. May I now request all the honorable dignitaries to kindly light the ceremonial lamp and officially inaugurate the function. Krishna Iyer, President, Sharada Krishna Subramanya Foundation for Law and Justice, for the welcome address.
Good morning to all of you. Honorable President of this meeting, the Chief Justice of Kerala, Honorable Mr. Justice K.M. Desai, Honorable Mr. Justice S.Narasimha, Judge, Supreme Court of India, Honorable Mr. R. Venkataramani, the Attorney General of India, Honorable Mr. Justice K.M.Joseph, former Judge of the Supreme Court, Adv.Sanand, Ramakrishnan, Secretary of SKS Foundation of Law and Justice. I am standing before you to welcome all those who are present here for this August function. Today we are assembled here on the occasion of the 9th Justice V.R. Krishna Iyer Memorial Law Lecture. Justice V.R. Krishna Iyer, an eminent humanist, commenced his political journey aligned with the communist movement, demonstrating remarkable adaptability across various roles. An erudite lawyer, legislator, minister, High Court judge, Law Commission member, Supreme Court judge, author, poet, and social activist. Excelling passionately in each pursuit, he embraced the society wholeheartedly. Widely acknowledged as a living legend of law, he garnered numerous awards globally. Guided by the philosophy, I am human and therefore nothing related to human can be alien to me. His impactful contributions are omnipresent and span across various domains, namely inspiring legal practice, influential legislative speeches, progressive ministerial reforms, landmark judicial decisions, law reform initiatives, prolific law literature of international recognition. Justice Krishna Iyer's enduring legacy lies in the indelible mark he left across these diverse realms, encapsulating a lifetime of remarkable service and dedication to humanity. We are extremely happy to have Honorable Mr. Justice S.Narasimha, Judge, Supreme Court of India, as the chief guest for this function. In Hyderabad, Justice Narasimha graduated in economics, political science and public administration before pursuing law at Delhi University. He commenced his legal career in Hyderabad and later shifted to Supreme Court, where he excelled in constitutional bench cases, served as Commission Counsel for Justice Chinnamurti Commission. Designated as a senior advocate in 2008, he notably argued in Ayodhya title dispute case. He was appointed Additional Solicitor General in 2014. He represented India before international tribunals and contributed significantly to legal development, mediation and arbitration. He was elevated to Supreme Court directly from bar in August 2021, and he is set to become the Chief Justice of India in October 2027, going by the seniority rule. On behalf of Sharada Krishna Subramanya Foundation and all others present here, I wholeheartedly welcome your Lordship to this function. Sri R. Venkataramani, the Attorney General of India, will deliver 9th Justice V.R. Krishna Iyer Memorial Law Lecture on Perennial Values of Constitutional Law as discovered by Justice V.R. Krishna Iyer. With over 44 years of legal practice, he has specialization in various branches of law, including constitutional law, arbitration law, indirect taxes, corporate and securities law, environmental law, criminal law, and human rights law. Enrolled as an advocate in 1977. He was designated as senior advocate in 1997 by the Supreme Court of India. Mr. Venkataramani has represented state governments, universities, and public sector undertakings in the Supreme Court and the High Courts. He served on the Committee on Directive Principles of State Policy and was co-operative member of the expert group for Ministry of Minority Affairs. Appointed as Attorney General in September 2023, he assumed office on 1/10/2023. His publications include a book on the judgments of Justice O. Chinnapareddy, a volume of thoughts in Harshvari's Laws of India, and he has made significant contributions to constitutional law, legal education, and environmental law. Actively involved in academia since 1988, Mr. Venkataramani has contributed to legal education reforms and served on academic councils and boards of various institutions. Sir, I with great pleasure welcome you to this function. Honorable the Chief Justice of Kerala High Court, Mr. Justice A.J. Desai was born on 5th July 1962 in Vadodara. He hails from a family of judges and lawyers. After graduating in BA Economics from St. Xavier's College, Ahmedabad in 1982, he earned a law degree from L.A. Shah Law College in 1985. He then enrolled as an advocate in Gujarat in 1985, where he practiced initially at the City Civil and Sessions Court, Ahmedabad, before shifting his practice to the High Court of Gujarat in 1991. With a diverse legal career, including roles as Assistant Government Pleader, Additional Public Prosecutor, Central Government Standing Counsel, he has handled many cases of constitutional importance. He was elevated as the Judge of the High Court in 2011, and he assumed the role of the Chief Justice of the High Court of Kerala on 22nd July 2023. With immense pleasure, I welcome your Lordship to preside over this function. Next, I am to welcome my brother, Honorable Mr. Justice K.M.Joseph, former Judge of the Supreme Court and patron of the Sayagala Krishna Iyer Foundation for Law and Justice. Justice K.M.Joseph's judicial history is highlighted by his pivotal role in Harish Chandra Rawat versus Union of India, where he quashed a presidential proclamation under Article 356 of the Constitution of India, challenging the imposition of President's rule in Uttarakhand. This judgment emphasized the importance of preserving the democratic process and federal structure, criticizing the use of Article 356 of the Constitution of India to dislodge democratically elected governments. Despite facing repercussions including delayed elevation to the Supreme Court, his courage and commitment to the judicial independence remains steadfast. In subsequent Supreme Court rulings, Justice Joseph continued to contribute significantly, addressing issues such as freedom of press, personal liberty, and the appointment process for the election commission, etc. The entire legal community acknowledged his wisdom and hopes to benefit from his continued insights. Though you are part of the foundation that organizes this function, still, you being an active participant in this program, I with great pleasure welcome you, brother, to this function. Adv.Sanand Ramakrishnan, present on the stage, is the Secretary of the Foundation. It was he who did almost all the work necessary for organizing this function, and he deserves a warm welcome to this function. I welcome you formally, Mr. Sanand Ramakrishnan. I am happy to notice that many judges sitting and retired of this court are present. I welcome all of you, brothers and sisters. I also notice with pleasure that 3 brothers from Gujarat have come all the way to participate in this function. Justice A.J. Shastri, B. Vaishnav, Justice Honorable Mr. Justice D. Vaishnav, Honorable Mr. Justice R.N. Chaya. Many lawyer friends, including senior lawyers, are present here. I welcome all of you friends with great pleasure. I welcome the students who have come here to receive the awards and their family members. I also welcome the teachers and students of the neighboring law colleges who have come to witness this program. I welcome the technical team of the online portal live now who are streaming this program live. I also wholeheartedly welcome the print and visual media persons present here to cover this function. I welcome all of you once again to this function. Thank you.
Here, may also extend a warm welcome to Honorable Mr. Justice K. Balakrishnan Nair, President, Krishna Foundation for Law and Justice. From them, KL07 CH5063. Moving on, may I now invite the Honorable Chief Justice of Kerala, Honorable Mr. Justice Ashish Jitendra Desai for the presidential address.
Honorable Justice Shri P.S.Narasimha, Judge Supreme Court of India, Shri R. Venkataramani, Learned Attorney General of India, Honorable Justice K.M.Joseph, former Judge Supreme Court of India, Justice K. Balakrishnan Nair, former Judge High Court of Kerala and President of the Foundation, my esteemed brother and sister judges, Honorable Justice R.M. Shaya, former Chief Justice, Guwahati High Court, Honorable Justice Ashutosh Shastri, Judge High Court of Gujarat, Honorable Justice Viren Vaishnav, High Court of Gujarat, esteemed former judges of this court, Advocate Shri Sanand Ramakrishnan, Secretary and other office bearers of the Foundation, ladies, learned judicial officers, respected senior lawyers, my dear junior lawyers, dear law students, ladies and gentlemen, good morning. Today marks a significant occasion as we gather to pay homage to late Honorable Justice V.R. Krishna Iyer and celebrate his enduring contribution to the evolution of jurisprudence in India. Justice is the foundation and the object of any civilized society. The quest of justice has been an ideal which mankind has been aspiring for. Justice Krishna Iyer's legacy serves as an eternal source of inspiration for all those committed to the pursuit of justice and advancement of the human rights. This is exactly why S.Narasimha famously said, "When V.R. Krishna Iyer speaks, the nation listens." Justice Krishna Iyer was a multifaceted personality with unparalleled intellectual capacity that is evident in his landmark judgments, books, poems, newspaper articles, speeches, etc. Most of us assembled here know of his having worn several heads in his illustrious life, that of an advocate, a legislator, a minister, a high court judge, member of the law commission, a Supreme Court judge, author, poet, social crusader, etc. His abiding philosophy was, "I am human and therefore nothing human can be alien to me." Undoubtedly, Justice Iyer was a visionary jurist whose profound commitment to social justice and human rights remained unparalleled. Throughout his illustrious career, Justice Iyer demonstrated an unwavering dedication to the marginalized and unprivileged, using law as a powerful instrument for sociality, transformation and value. His seminal judgments on the varied subject, especially protection for fundamental rights, have left an indelible mark on Indian legal landscape. By interpreting the law in a manner that reflected the socio-economic realities of the country and the spirit of Constitution, Justice Iyer significantly influenced the jurisprudential discourse in India, emphasizing the need for a more compassionate and inclusive legal system. Most importantly, Justice Iyer's unflinching dedication and commitment for the triumph of human values by offering a beacon of hope to those who are unheard in the society is exemplary. Throughout his life, he was a crusader for justice and his way of life embodied the highest values of simplicity, the finest attention to even the smallest nuances of details, and unflinching discipline in everything he undertook. We know from his writings that continue to inspire all of us. Truly, his life was an extraordinary one and legacy. We have gathered to remember and honor him today. His legacy serves a guiding light, using us to continue our collective efforts in upholding the principles of justice and equality in our legal framework. Let us draw inspiration from our unwavering commitment to those cause of oppressed and work towards creating a more just and equitable society. It is my absolute honor to share the dais with the esteemed chief guest, Honorable Justice P.S.Narasimha, for today's event. Justice Narasimha's exceptional legal acumen and his profound contribution to the Indian judicial system have earned him widespread admiration and respect, which led to his being recommended for direct elevation to the Supreme Court of India. His insightful judgments have not only strengthened the rule of law but have also played a vital role in shaping contemporary legal discourse in our country. We are truly honored to have him grace this occasion with his presence and wisdom. Furthermore, it is an honor to have with us Sri R. Venkataramani, the esteemed and erudite Attorney General for India, to address this august gathering and deliver the 9th Justice V.R. Krishna Iyer Memorial Law Lecture. The topic chosen by him, namely Perennial Values of Constitutional Law, discovered by Justice V.R. Krishna Iyer, is of great relevance to legal fraternity. It is also an honor to have Honorable Justice K.M.Joseph, former Judge of Supreme Court of India, and who is a patron of the Foundation, join us today to address the gathering on this occasion. In conclusion, let us take this opportunity to reflect on the remarkable legacy left behind by Justice Iyer. The pages of history will inevitably crown an invaluable contribution of Justice Iyer in golden letters. As we all know, he had poet's heart, which reflected in his writing that were full of compassion and abiding love for humanity. For generations to come, Justice Iyer serves as a beacon of superlative intellectual capacity and as a great humanist who served people and made the world a better place through letter of law. I once again express my sincere gratitude to the office bearer of the Foundation for giving me this opportunity. Thank you all.
Attorney General for India. A remarkable litigation career spanning over 4 decades, with specialization in constitutional law, law of indirect taxes, human rights law, civil and criminal law. Former member of Law Commission of India in 2010 and 2013. The Honorable Attorney General is an astute lawyer, a scholar, a human rights activist and a poet. We are extremely privileged to have the gracious presence of the Honorable Attorney General, Mr. R. Venkataramani, with us today. I cordially invite him for the 9th Justice V.R. Krishna Iyer Memorial Law Lecture on the topic Perennial Values of Constitutional Law, discovered by Justice V.R. Krishna Iyer.
Tongue-tied, I can be in the presence of Justice Narasimha and Justice K.M.Joseph. Deeply learned and with a keen intellect, probably waiting to have their mark sheet for me for my today's lecture. But I thank Sanand for keeping me in mind and the patron of this association to invite me here today to be part of a gathering. Many of you might have moved very closely with Justice Iyer, might have been part of many of his activities, either closely or from a distance. And that gives me a great pleasure to be here today. Thomas Nagel, a philosopher, while writing a foreword for John Rawls' theory of justice, among other things said about the book, he said it's a hopeful possibility, hopeful affirmation of human possibilities. Justice Krishna Iyer was a hopeful affirmation of human possibilities. So I'm indeed delighted to be here to share my few thoughts. And as we travel along in the course of my exchanges with you, not only share my thoughts but probably engage the younger generation of students who are here today to keep themselves, I said, engaged in this hopeful affirmation of human possibilities. And that, I think, is the fundamental task of being a lawyer. And of course, when you're on the bench, that will be uppermost in your mind. I also seek apologies for reading out from my prepared speech, though an extempore speech would have probably caught the attention of the listener, every second, right? I think since the thoughts which I have gathered may be deserving of a publication later, I put it in a form of a speech, written speech. The act of creation by human mind has been well written about. Much before Arthur Kiesler wrote about the act of creation, the creative element of human mind has been studied, though referring to works by artists or musicians or poets. In what sense can we talk about the creative activity in other fields? We talk about original thinking in various fields of human thought and activity and applaud them for their appeal and relevance, used or simply for their intellectual beauty. Can we import any of those into the legal domain? Many have written about the motions of the common law, from Holmes to Frederick Pollock. The freedom assumed by the judicial branch to find solutions to new questions, guided by the maxim where the right remedy must lie, has been treated as one of the core features of common law. The felt necessities of time, as Justice Holmes talked about, and the perfection of reason, as the moving spirit behind the genius of the common law, are all well inscribed in judicial pronouncements and academic writings. The story of a nation's development and its law cannot be dealt with as if contained in the axioms and corollaries of a book of mathematics, said Justice Holmes. What is the foundation of creativity in justice administration and good and relevant in all contexts, more particularly in constitutional governance, which may demand continual creation of a world of equal relations? To quote Professor Upendra Bakshi would be opposite. I quote, "One would ordinarily think that the Constitution required rather the creation of an uncommon law, that the invention of a whole series of sui generis interpretive traditions in which even judicial deference to legislative policy was to be firmly disciplined by the inherent logic of fundamental rights and human freedoms outside of the chain of precedent. Ledger keeping produces accounts, but what is required is the politics of production of accountability," said Professor Upendra Bakshi. I said therefore that the common law of the Constitution is just not mere lexicographic intellectual insemination, but the cause for sweeping social dialogues. As a student of law in the Government Law College, Pondicherry in 1975, I had my first acquaintance with Desai. I had the pleasure of accompanying him from Chennai to Puducherry when he came to the Law College at an invitation of Professor N.R. Madhavan, the then principal of the college, a legendary figure by himself. Desai had recently lost the most precious part of his life, Mrs. Sharada, his companion in life. Not fully arrived in the depths of the sorrow, I tried to engage Desai on issues of philosophy, modern physics, and a just social order. I vividly recollect that I exposed the shallow reaches of my knowledge and how Desai spoke with me without an air of authority, but kindling my interest further. This foundation saw the next stages of my association with him soon after my practice shifted to the Supreme Court in 1979. Membership in the Indian Association of Lawyers gave me rewarding opportunities and occasions to interact with the judge. Seldom have I seen him but addressing without a dictation to his stenographer, without a book on his table or a task on his mind. Few instances of research contributions by me and their critical reception by him made me ask this question: what kind of mind does he possess? While I had read and used some of his judgments, even while he was on the bench, the jurisprudential potential and his expanse dawned on me much later. My continued association with him after his retirement really contributed to the understanding of the man and his work. The countless instances of association with him in human rights and social justice issues, from housing rights to gender rights, from free and fair elections to right of minorities, and many more, from rights of tribal populations to matters of environment, were exciting exercises, enriching my own personal comprehensions of shades of political ideologies, philosophies, history, and on top of it all, the ABC of compassion. It would be, of course, a fruitful, rewarding, as well as a fascinating journey to travel along with Justice Krishna Iyer from his Kerala High Court days and all those tireless years of judicial craftsmanship, of rare order in Supreme Court when he penned opinions of great persuasive jurisprudential and literary value. When somebody says there is no nourishment in biography, we can unhesitatingly turn our backs and opt to log on to a quiet Himalayan retreat and inhale the great nourishing value which Justice Krishna Iyer breathed into the yoga of law and justice. However, the task of crafting Justice Iyer's monumental yoga of justice is not undertaken here. Creativity in science and technology is not guided by ideological persuasions or dictated by political desirability. Art and poetry may, however, seek to express philosophy or any matter about the human condition. Politically articulated thoughts may seek ever-refining frontiers and possess creative elements in looking at social issues. Law seems to position itself somewhere between these subjects. The freedom of the common law also can be seen as a phenomena of creativity in a special sense. The question, however, will be what limitation or what boundaries will inform and guide the legal thought process. Will acting under constitutional demands call for freedom of the judicial branch to determine its own boundaries and thus an undefinable matter externally? Who will codify and practice the institutional demarcation or separation of powers? Even if the Constitution places a distinct trust and obligation on the Constitutional Court to articulate meanings and roadmaps through interpretive processes, can this process by itself become the codifying process of separation of powers? This primary constitutional question, born with the idea of constitution, and its answer, howsoever written, will be the Noah's Ark for a long journey towards liberty for all. The only difference will be that the members and passengers of the constitutional Noah will keep changing, unlike the chosen ones of the biblical ark. Before I proceed to engage a little more on the apparently mystical part of contemporary jurisprudence, let me ponder on a few perennial values of the Constitution and how Justice Krishna Iyer spent a lifetime crafting them in his opinions. His worldview was deeply anchored in liberty of all and all for liberty. When liberty of all does not lie in the hearts of men, as Judge Learned Hand asks about, social and individual power will remain problematic. Thus, he did look at the Constitution as an instrument of refining all power through the political process and the court as an instrument of deliberation and social participation. The court, he thought, should navigate the schemes and provisions of the Constitution to bring together all institutions to work on the common pursuit of liberty for all. The idea of common law court creating interstitially, though often cited by him, Lord Denning was often cited by him, was a minimal portrait of a constitutional court. Let me quote what Iyer said in Sunil Batra. And in an appeal to human tomorrow, if none responds to your call, walk alone. Walk alone. Judicial power of the human domain trust to drive the blade a little forward in your time, and to feel that somewhere among those billions you have left a little justice or happiness or prosperity, a sense of manliness or moral dignity, a spring of patriotism, a dawn of intellectual enlightenment, or a stirring of beauty where it did not exist before is enough, end quote. In his preface to the book Human Rights, Justice and Constitutional Empowerment, Justice Iyer captures the above idea in the following words, I quote, "Law is a social science and operates as an engineering adventure geared to people's material well-being. Justice confronts new social, economic, cultural, and political problems, and the law weaves fresh woods and pasture new to restore equality and justice." In the famous write-up by Justice William J. Brennan titled The Constitution of the United States, Contemporary Ratification, which was in a way a response to a speech made by the then Attorney General Edwin Meese in support of jurisprudence of original intention, the judge observed thus, I quote, "Our amended Constitution is a lodestar for our aspiration. Like every text worth reading, it is not crystalline. The phrasing is broad and the limitations of the provision are not clearly marked. Its majestic generalities and ennobling pronouncements are both luminous and obscure. The ambiguity, of course, calls for the interpretation, the interaction of the reader and the text. Of judicial interpretation is to translate the majestic generalities of the Bill of Rights, conceived as part of the pattern of liberal government in the 18th century, in concrete restraints on officials dealing with the problems of 20th century. Because we are at the last word on the meaning of the Constitution, our use may be subject to revision over time, or the Constitution falls captive again to the anachronistic views of the long-gone generation. I quote, "I do see an echo of the fresh woods and pastures new, just as Iyer had in mind in the above statements." One of the leading legal academics whose teachings and writings have influenced both the judicial engagement in constitutional action plans as well as legal education, Professor Bakshi said that, quote, "Legislation and adjudication in substance are political processes involving the exercise of power and authority through reason as well as fiat." Quote, "While legislation and adjudication can be seen as political processes, at a certain conceptual level to lay bare the working of the logic in both of them, yet they are dissimilar political processes, dissimilar in many respects. The one cannot become the other." Just Iyer was keenly alive to this understanding. I will quote here what S.Narasimha had to say, something closer to the above understanding. Of the first period, the historian will say that the Supreme Court moved towards its finest hour a day before the proclamation of emergency, when on 24 June 1975, in the best traditions of the judiciary, Krishna Iyer granted a conditional stay of the order under appeal, although he had been reminded by an eminent counsel, N.A. Palkewala, that the nation was solidly behind her as the Prime Minister, and that there were momentous consequences, disasters to the country, if anything less than the total suspension of the order that appeal were made. Judge K.M.Joseph, Vice President of the Court of Justice for the European Union, refers to the European Court as the constitutional umpire of the Union. Judge Aaron Barak, former President of the Supreme Court of Israel, said that he regards the judge as a partner in creating law, and he says that judges must use the legitimate tools to achieve their goals, and in the absence of existing tools, one should consider creating new tools. A prominent biographer of Judge Hon'ble offers the following description of the mindset a good judge should have. I quote, "The good judge is genuinely open-minded and detached, heedful of limitations stemming from the judge's own competence and above all from the presuppositions of a constitutional scheme. The good judge recognizes that a felt need to act only interstitially does not mean relegation of judges to a trivial and mechanical role, but rather affords the most responsible room for creative, important judicial contribution." I quote, "It is said that many have preached the above ideal, but very few have come as close to realizing it as Judge at hand." The piece I am talking about is not a judicial biography of some sort of Justice V.R. Krishna Iyer. He is too large a persona to be capsuled merely within the common genre of a great or the famous judge. Judge Richard Posting is forward to the biography of Justice Henry Freedley writes thus, "He had not had an exciting early life like Oliver Wendell Holmes or Byron White. He was not a character like Leonard Hand, or an enigma like Cardozo. He had not been involved in greater political events like Brandeis, Frankfurter and Robert Jackson. And I quote, I may venture to say that Justice Krishna Iyer is all of the above judges put together and a blend of a different amalgam. There are other great names who have transformed law and its relevance, and there are those who are drummers ahead of their times. Having had the opportunity to be associated with him in many activities and over a fairly long period, my views can be both colored and also well informed. I will, however, endeavor not to be hagiographical. I shall focus on a few perennial values of the Constitution as articulated by Justice Iyer and how they have been enriched by subsequent judicial engagements. They are: 1. Equality as both making new and undoing the old. 2. Dismantling the blindness of power to all values of liberty. 3. Dismantling monopoly of reason outside the Constitution. 4. Opening up avenues of remedy for every right and the need for articulating access to justice. 5. Empowering the deprived by gender, caste, economic and other social phenomena. And finally, proportionality as a tool of legal evaluation. When I say perennial values, I mean stretching into such distant future when all humanly created divisions would have withered away, as it was expected that the state will wither away. We may need to live with the perennial values as our tools for continued articulation of justice, social, economic and political. Just Iyer did foray into other deeply important matters of institutionalizing democracy and breathing accountability into the political and governance process. What he reflected in Samseshin's case is not only about the institution of the governor in isolation, but equally about articulation of power and how institutions can enhance the ethical contours of power or decimate them. Governors acting beyond the ministerial advice was seen as a peril to democracy, as also the importance of accountability. The long shadow of Samseshin fell eventually on S.R. Bommai, which now informs and navigates the Supreme Court on its supervisory role on governmental functions, speaker's authorities, and the Schedule 10 working. Few preliminary statements may be needed. The Iyer is alive to the infallibility of the human mind and is open to the pitfalls of conversion of creativity of judicial thought into binding principles of political prescription. He often quoted Justice Jackson and finality and infallibility of the Constitutional Court. The wavy but necessary line of separation of powers was ever in his mind. Both in Samseshin and in Maneka Gandhi, he tried to keep allegiance to this principle, which has its own internal dynamics, which neither age nor custom will wither. But he entered a duality too in Nawab Khan with Abbas Khan, as I will be later. In a precedent-bound world of lawmaking and justice dispensation, the freedom to navigate freely, though not like Don Quixote, is problematic. Courts keep moving within judicial discipline and responding to the felt needs of times. Within the perseverance to correct errors, and only great errors, constitutional problems are not treated as mere subjects for mental exercises. Socio-economic rights demand two levels of constitutional focus. The first is the articulation of competing claims and their respective fields, which may include enumerating layers of rights and interpretive process. This is the role of the court, though the same can be and deserves to be done in legislative and executive chambers. The second is the evaluation of economic and social outcomes, the costs of enforcements, the institutional measures for enforcement, and the management of enforcement of all, which are not essentially quantified or performed like a music opera. These matters call for approaches outside the mere judicial lens. However, the two levels must meet in order that democracy functions. The perennial values I mentioned above will, as we move further into the country's march into a country where equality will shine, as the relationship of all of us continue to guide us. Equally, the legal fraternity will have to coin new statements to meet the challenges. The scope for making radical statements on doing justice, or rewriting express words of the law, or expounding the constitutional text beyond its space while appealing and stirring one's heart and mind, which means political, social and other beliefs on the affairs of the community, may be still bound by precedents. The journey in this terrain for a mind attentive to human pain, suffering, personal peace and joy in a society woven with diversity and inequality is a journey of values. And I should say that Iyer undertook the journey by crafting his philosophy into existing frameworks of justice and understanding of procedures. While we have the job of delineating the connection between rule of law, promotion, fair justice and legitimate political order, it's impossible and nay foolish to close one's eyes to the relevance of judicial interventions and declarations in matters of governance, and to the serious and well-meaning criticisms of what is stated as the judicialization of politics. We need to engage ourselves deeply in these debates, and the need to go beyond to improve upon Montesquieu and Tocqueville, who are all talking about the tyranny of political assemblies. Tocqueville himself made the following time-transcending observation, I quote, "The Americans have given their courts immense political power, but by obliging them to attack the laws by judicial means, they have greatly lessened the dangers of that power. I wonder if this way in which American courts behave is not both the best way of preserving public order and the best way of favoring liberty," unquote. All of us are entitled to ask philosophical questions as to what is the purpose of life, what value life holds to the community, and what is that makes endeavors in life relevant and fulfilling. These and other questions need not necessarily be confined to the domain of philosophy. They equally and essentially matter of the political process. The demands of the community towards promotion and protection of individual autonomy and towards measures in support of the same are deeply embedded in the political process. So also, the demands of ordered liberty and demands of the community from individuals towards ensuring communal orders, moral understanding, religious faith, etc. are equally part of the political process. The wise management of the competing demands and the gradual dilution of the inevitable frictions arising out of the heat and moment of competition and conflict is the constitutional process, which should inform both the political assembly and the judicial branch. Immanuel Kant, the German philosopher, exclaimed about the starry heavens above and the moral world within. Thus, Iyer's judicial reflections are grounded on these two aspects. I may profitably quote the wise reflections of K.K. Matthew from his lecture on natural law and its impact on courts. I quote, "Acquaintance with natural law is naturally as progressive in mankind as anything else. Mankind did not know all the laws of physics or electronics by right of birth. There is no reason why the last word on natural law should be had all at once any more than the last word on physics. The moral world is not less mysterious than the physical world," unquote. Let me deal with each one of the perennial values I mentioned above. Number one, opening up avenues of remedy for every right and the need for articulating access to justice. The access to justice principle, though ancient, has its fascinating evolution through constitutional law. The right to sue and defend in courts, as the US Supreme Court said in Chambers v. Baltimore, is the alternative to force. Courts are not merely safety walls or taming spaces, but institutions where force, power, or coercion, or evasions to accountability to one's conduct can be challenged. In constitutional space, what does it mean? Access to justice, as Justice Iyer pondered, was not confined to suing in courts for settling property or contract disputes. It transcended the traditional domains of litigating. It meant using the Constitution in aid of protecting, promoting, and delineating liberty, and using constitutional tools to advance egalitarian ends. The use of force, direct or indirect, subtle or gross, in social, political, and economic transactions to maintain the status quo or in undertaking social transformation, which is what revolution do by force, must yield to orderly and non-coercive processes. Thus Iyer called it the third world remedial jurisprudence. Now this immaculate conception of access to justice is a global constitutional phenomenon. It is wedded to basic structure. In fact, it should include access to legislative and executive justice. In a way, ability to choose an able, ethical, and informed representative in the legislature and processes for choosing or all access to justice. What good will be if the legislature is uninformed or ill-informed? Judicial engagement with the details of the claim, even when a case fails on merits, as observed by Douglas A. Kaiser, helps to frame the plaintiff's suffering as a legible subject of public attention and governance. Quote, this statement captures Justice Iyer's unstated logic and stretch of access to justice. In the Congo-Union case, the line between maintainability and justiciability in fundamental right adjudication was drawn to underscore the regulatory aspect of access to justice. I think that the regulatory value of judicial governance, of its time and resource, is a value very often lost by courts, as one finds that access to justice has also become access to public debates in courts. In the Fertilizer Corporation Congo-Union, Justice Iyer states as follows. A pragmatic approach to social justice compels us to interpret constitutional provisions, including Article 32 and 226, with a view to see that effective policing of the corridors of power is carried out by the court until other ombudsman arrangements a problem with which Parliament has been wrestling for too long. Long are they conceiving that the social auditor and his audit function can be put into action only when someone with a real public interest ignites jurisdiction. In a society where freedom suffers from atrophy and activism is essential for the participation of public justice, some risks may have to be taken and more opportunities open to the public by citizen to rely on the legal process and not to be repelled from it by narrow pedantry now surrounding locus standi. Unquote. Next, dismantling blindness of power to all values of liberty. Let me gather Justice Iyer's thoughts on liberty. Whenever he wrote about liberty, it was mostly about the oppressed and the voiceless. In Maruram, he said, quote, issues of liberty are healthy politics, and those sincerely committed to human rights must come to the support of the poor prisoners who have no votes nor voices. Unquote. In Charles Shawbrown, he integrates the constitutional triumvirate of Articles 14, 19, and 21, building Cooper and Maneka Gandhi to the rescue of prison inmates. In Premchandra Shukla, handcuffs and bar fetters became fit subject for a habeas corpus inquiry. Today, scope of habeas corpus inquiries cover many concerns beyond illegal confinements. The Liberty Manifesto under Article 21 now contains many chapters. The dignity discourse elaborated with Supreme Court in Shreya Shingal and Kuduswamy are products in a way of the Maneka Gandhi speech. The statement in Maneka Gandhi called the ambit of personal liberty Article 21 is wide and comprehensive, was thus pressed into service to deal with deprivation even inside prison walls. For Justice Iyer, it is not a prison wall that mattered, but that no power should be blind to all values of liberty. The following quote from Costa Nimola in Premchandra Shukla was his constant companion in many speeches and writing. I quote, when they arrested my neighbor, I did not protest. When they arrested the men and women in the opposite house, I did not protest. And when they finally came for me, there was nobody left to protest. Quote. He condemned the sole fact of life, that discriminatory treatment based upon wealth and circumstances died hard under the Indian sun. Who can lose one's eye to the ascent of Article 21, liberty jurisprudence, into virtually the daily landscape of courts discourse today? The conversion of the Code of Criminal Procedure today into a constitutional code of rights and duties flows from the consolidation of such principles. Bail, not jail, became a watchword of the criminal justice process. Equally important, he said, is the deplorable condition, verging on the inhuman, on offered sub jails, the unrewarding cruelty and the expensive custody of avoidable incarceration makes refusal of bail unreasonable, and a policy favoring release justly sensible. Quote. He understood that Campbell did not specific project projected by each case, so that it is today we talk about the need for a bail law, fair trial, speedy trial, rights during incarceration are now integral to and inseparable from criminal justice. Article 39A came to be inserted by the 42nd Amendment while Justice Iyer was on the bench. It is no coincidence that he strongly recommended a public defender system suitable to the Indian condition. The penetrating vibrancy of the ideas and their irresistibility to large measure owed to Justice Iyer. The National Legal Service Authorities Act, which has now grown many wings, also owes its birth to those powerful impregnations. I fondly recollect the little role that some of us played in the debates and motions that went into the shaping of this law and in the incubation of the Supreme Court Legal Services Committee under the debatory jurisprudence inspiration of Justice Iyer. Next, equality as both new understanding and undoing the old. The Equality Charter enacted in Articles 14 and 16 read the directive principles in Articles 39, 41, 42, 43 and 46 constituted the framework for Justice Iyer, the social justice charter of the Constitution. In fact, the entire Constitution in itself is a social justice document. The preamble that talks about justice, social, economic and political. In the act of organizing and codifying all power, the Constitution has visualized liberty of all citizens as its journey. Only when liberty in all its facets is secured for all citizens can there be a flourishing of other concerns of life. In Maneka Gandhi, the Desai talked about the watershed between a police state and a people's wrath, and how policy should be operationally respectful and of recognized values. His judgment in C.V. Muthama is an instance of demanding such operational respect, but not only recognized values, but a call for recognizing the value of gender equality in due proportion. His statement that where differentiation is not demonstrable, rule of equality must govern is a balancing principle closer to proportionality. The Iyer in C.V. Muthama also penned down his condemnation of gender inequality in the following words, I quote, "If a married man has a right to a married woman, other things being equal, stands on no worse footing. This misogynist posture is a hangover with the transparent culture of mantling the weaker sex, forgetting how a struggle for national freedom was also a battle against women's thraldom. Freedom is indivisible, so is justice. That our founding faith contained in Articles 14 and 16 should have been tragically ignored vis-a-vis half Indian humanity, namely our women, is a sad reflection on the distance between the Constitution in the book and law in action. We do not mean to universalize the dogmatize that men and women are equal in all occupations and all situations, and do not exclude the need to pragmatize where the requirements of particular employment, the sensitivities of sex, or the peculiarities of societal sector, or the handicaps of either sex may compel selectivity, but say where the differentiation is demonstrable, the rule of equality must govern." And quote. Then Iyer's root taught in Akhil Bharatiya Social Karamchari's son probably reflects on the caste censorship in our society. He said, "The abolition of slavery has gone on for a long time. Rome abolished slavery, America abolished it, and we did, but only the words were abolished, not the thing. This agonizing gap between hortative hopes and human dupes vis-a-vis that serf-like sector of Indian society strangely described the scheduled castes and scheduled tribes, and the administrative exercises to bridge this big hiatus by processes like reservations, that is a concession in the field of public employment, is a broad issue that demands constitutional examination, not philosophically, but pragmatically." And quote. He also used to quote Karl Marx's famous statement of the Communist Manifesto. Philosophers have only interpreted the world in various ways, but the point, however, is to change it. These are the founding fathers fighting faith and serve as a perspective setter for the judicial censor. The animating sense of equality, in order that the promises of the Constitution are not teasing illusions, is captured in N.M. Thomas as follows, quote, "Social engineering, which is law in action, must adopt new strategies to liquidate the encrusted group injustice or surrender society to traumatic tensions. Equilibrium, in human terms, emerges from release of the handicapped and the primitive from persistent social disadvantage by determined, creative, and canny legal maneuvers of the state, not by hortative declarations of arid equality. To discriminate positively in favor of the weak may sometimes be promotion of genuine equality before the law, as Anthony Lester arguably said. The basic question, that is one of social dynamics, implied in Article 16.1, let's go to the fundamentals and ignore the frills. In a spacious sense, equal opportunity for members of a hierarchical society makes sense only if a strategy by the underprivileged of environmental facilities by developing the full human potential. This consummation is accomplished only when the utterly depressed groups can claim a fair share in public life and economic activity, including employment under the state. This Iyer quotes his own words in J.N.K. State with K.M.Joseph. I just quote one part of the paragraph. In this unequal world, the proposition that all men are equal has working limitations. Since absolute equality leads to Procrustean cruelty or sanctions indolent inefficiency. Necessarily, therefore, an imaginative and constructive modus vivendi between commonness and excellence must be forged to make the equality clauses visible. My conclusion is that genius of Article 14 to 16 consists not in literal equality, but in progressive elimination of pronounced inequality. Indeed, to treat sharply dissimilar persons equally is subtle injustice. Equal opportunity is a hope, not a menace. Unquote. While succinctly remarking that silence is not always golden, in N.M. Thomas, he emphasized the need for eruditeness in legal exposition. He quoted Justice Brennan and Justice Holmes and examined law at the epicenter of social engineering. And he said, the father of the nation adopted as his fighting fate the uplift of the Bangi and his assimilation on equal footing into Hindu society, and the constitution, whose principal architect was himself a militant Maha, made societal justice a founding faith and built into a humanist provision to lift the level of the lowly scheduled castes and tribes to make democracy viable and equal for all. And said, till date, one of the finest and refined judicial observations about Mahatma Gandhi. Just Iyer's opinion in this case also embarks upon the value of presidential guidelines, while he notes that, am alive to the correctly reluctant attitude of this court to depart from Presided, lest an unstable and uncertain situation be created. Sadly, this is not quite aware. End quote. Next, dismantling monopoly of reason outside the Constitution. Democracy has altered the fundamental principles of governance. Rule of law through constitutional governance is a further move away from engagement of private reason and the reason unregulated by public mediation. Elections, legislative debates, print and visual media, and now social media are sites of public mediation. While the refinement of these sites are extremely important, their current deficiencies need no detraction. The emergence of public reason as a vessel for public discourse, though through a difficult marriage of diverse logic and diverse ideologies, is said to be the tool for a vibrant democracy to work. Public reason demands reciprocity in the minds of conflicts and inequalities, and also that recourse to moral and metaphysical convictions may be more often necessary. The accommodations, the adjustments, the agreements between differing views and values is however modified by the idea of constitution as a non-negotiable principle. After all, as John Rawls says, the reasonable society is a community neither of saints nor egoists. And he says further, all have their own rational things they hope to advance, and all stand ready to propose fair terms that others may reasonably be expected to accept, so that all may benefit and improve on what everyone can do on their own. Unquote. The liberal principle of legitimacy underlying public reason is further captured by John Rawls in the following words. Quote, the point of an ideal public reason is that citizens are to conduct their fundamental discussions within the framework of what each regards as a political conception of justice, based on values that the others can reasonably be expected to endorse. And each is, in good faith, prepared to defend that conception so understood, unquote. It can be seen that there is a tall demand on reasonable expectations of reasonable behavior. Rawls also says that judges may not invoke personal, moral or religious views, but must, he says, appeal to the political values they think belong to the most reasonable understanding of the public conception of justice. Values they believe in good faith are generally accepted. Quote. The parallel drawn by Rawls between court and citizen as regards the role of public reason is open to debate. The attempt to invoke public reason as a common carrier of citizens and courts in managing democracy is a challenging task, but a necessary task. There can be no final set of rules to be set down for this multi-purpose vehicle, except that the spaces available for good faith endorsement of values and norms for citizens, governments and courts will be different. We are just looking at a version of deliberative democracy that should transcend the familiar division between procedural and constitutional conception democracy, where mutual respect and disagreement can sit together in a boat to be rowed on a wavy seas. If the little boat is to be oared by all, the oars must be held by all of us as if in a choir. So it is that we understand the role of constitutional courts, like a doctor's duty to act in the best interest of the patients, that they are forums of principle, and endeavoring to generate constitutional grammar into government's arithmetic. Maneka Gandhi dictum has opened up the scope for debate and public reason by integrating Articles 14, 19 and 21. It is said that we have moved away from a culture of submission to the ruler to one of justification of all state action. Ekagopalan ruling for the Supreme Court was in a sense a perception of the form of law as sufficient to law. The distinction between the form of law and its justification are important for climbing higher levels of democracy and fairness. Maneka Gandhi's dictum is an irresistible appeal to be wedded to the principle of justification of a law. The German jurist Ehring wrote, I quote, "Law is not less a product of history than handicraft, naval construction, technical skill, as nature did not provide Adam's soul with a ready-made conception of a kettle, of a ship, or of a steamer. Even so, she has not presented him with a property, marriage, binding contract, and the state." And the same will be said of all moral values. The whole moral order is a product of history, or to put it more definitely, of the striving towards ends, of the untiring activity and the work of human reason, tending to satisfy wants and to provide against difficulties. This providing against difficulties question is a constant challenge in a democracy. Multiple layers of reasonings collide and demand equal or exclusive space. We thus land into organizing several principles of debate management. The debate management in constitutional courts ultimately ends in the justification principle, which we demand from government branches. This principle of justification may have its Achilles heels, namely the subtle infiltration of subjectivities of judges into a powerful canvassing of ideologies and values. Constitutional interpretation is a practical activity with a heavy normative character. In such circumstances, there will always be a today and tomorrow. This, I understand, is the beauty of constitutional governance and the struggle of the human condition to strive towards spaces of peace and comfort. Next, proportionality as a tool of legal evaluation. The claim to correctness in law and governance is a contested area. Justice Iyer grasped this aspect profoundly. Democracy is both a conjunction of institutions and their sustained motion with the aid of the Constitution and within it. This conjunction can consist of both crossroads and confluences. Crossroads arise when citizens' values, whether of a section or otherwise, are articulated differently from the content and working of a law. Confluences happen when courts with their versions of the law and the Constitution bless the values of law as the best understanding of a social problem or an issue, or as a desirable solution to a conflict. These are matters of readings and interpretations of the law. In these readings and interpretations, various versions of proportionality enter. I may like to quote the German writer Gustav Radler. Quote, "The conflict between justice and legal certainty may well be resolved in this way. The positive law, secured by legislation and power, takes precedence even when its content is unjust and fails to benefit the people, unless the conflict between the statute and justice reaches such an intolerable degree that the statute as a flawed law must yield to justice." I quote. This in essence is a proportionality proposition of fundamental character. Matters of intolerable degree, conflict, flawed law, all involve questions of impact of a law on citizens' rights, nay even the articulation of rights, and very often the penumbral dimension of rights. This can also arise when the definitional framework of law itself may call for plumbing multiple values or matrices to anchor a roadmap for the law. The argument of the US Supreme Court in Griswold vs. Connecticut about implicit ordered liberty written into the Constitution as the basis for recognition of unenumerated rights has been a persuasion in India for reading implicit meaning into fundamental rights expositions. The reading of right to know as inherent in the right of freedom of expression under Article 19(1)(a) is a well-known instance. I will pick up a case rather remote to illustrate this aspect. What is an industry within the scope of industrial disputes law? Was it a mere question of interpretation of vague definition, misty in origin, and uncertain due to passage of time? Desai saw in the nature and purpose of a law tool to address a fundamental question of industrial justice and the importance of empowering the working class. The argument that the result of a wide meaning given to industry has led to distortions in economic relationships and made the trade unions irresponsible in the collective bargaining process forgets that economic empowerment is connected to social and political empowerment. This empowerment dimension is a substantive proportionality argument. In fact, today the reason for such reading of the law may not be so necessary in view of the relative enhancement of conditions of employment and the welfare benefits that provide a more secure work environment. Proportionality talk is now an embedded part of our constitutional dialogue. From being a measure of penal action in Ranjit Thakur's case, it has entered the reasonableness discourse as to be seen in the modern dental college judgment. Well-settled proportionality aspects talk about three standards, namely the ends benefits, the alternative means, and the limitations on action. The alternative means aspect was considered from a utilitarian paradigm in Mohinder Singh Gill was the Chief Election Commissioner. The case does not, of course, wear the apparel of proportionality on its face, but in essence, it is premised on the means ends principle. The recent pronouncements on proportionality, though by the Supreme Court, though picked up threads from Canadian, English, and US judgments, we can notice the silent impact of the utilitarian analysis. Economic, social, and political empowerment and equality readjustment are proportionality issues. Proportionality principles can take many forms. In art and architecture, for example, proportionality refers to the balanced relationship between two quantities that vary in a fixed ratio. The later usage also occurs in political theory and election law, where writers and courts speak of proportional voting strength or representation. Similar fixed ratio proportionality concepts appear in legal or informal contexts where co-owners or beneficiaries expect to vote or receive proceeds corresponding to respective fractional shares. In criminal law and philosophy, proportionality is often discussed in relation to theories of punishment. In Iliga Enama, Desai did not condone the criminal conduct of a woman while he strongly opposed the death penalty. It is difficult to justify this dichotomy in Iliga Enama, but one can see proportionality in its weak form at work. What I wish to say the proportionality analysis can sometimes hide its subjectivity behind rules and carry placards of objectivity. I may add that public reasoning, proportionality are matters that can legitimately flow from judicial reasoning to inform legislative deliberations. Finally, empowering the deprived by gender, caste, economic and other social phenomena. In Akhil Bharatiya Social Karamacharism, Iyer asked a question which has now become a debate of many colors. He pondered the under, quote, except the traditional self-perpetuating quasi-apartidization or reservation. Surely, our democratic, secular, social republic is no vague moon, but a creative power rooted in equal womanhood and manhood, an egalitarian reservoir of vast human potential, a demographic distribution of talent, unquote. The raging controversies of overdoing affirmative actions for the deprived versus equality claims of others were keenly portrayed by Desai, while noticing the submission that a vested interest in the caste are constant vigil on undoing social barriers that hover around in many subtle forms and reincarnate in many new shades, just Iyer said. Whether alternative policies should have been chosen by government or would have served better to remove the handicaps of SC and SC, but the advantages conferred on these classes are too generous or beyond the court's arbit, nor is it the court's province to question the conscientiousness of propriety of constitutional provision which display ultra concern for members of the SC and ST. The court functions under the Constitution, not over it, interprets the Constitution, not amends it, implements its provisions, not dilutes it, through personal philosophy projected as constitutional construction. Even so, while viewing the legal issues, we must not forget what is elementary, that law cannot wait alone, but must function as a member of the sociological ensemble of disciplines. Unquote. In N.M. Thomas, the court further drew an important idea of constitutional integration. For a long while, reading of Part 3 has remained away from the blend of Part 4. The persuasive voices of Justice Matthew and Desai spoke in unison on the constitutional synthesis of Part 3 and 4. The statement by the court that in the process of interpretation, Part 4 of the Constitution must enter the soul of Part 3 of the Constitution has now become the grammar of interpretation of Part 3 of the Constitution. If Part 4 is the soul, it must find its living body. While Part 4 is not an invisible part of the Constitution, its floating meanings, waiting to be woven into working principle, are the great equality appeals gathered from the lessons of history, and in that sense, the vibrant cohabitant within Part 3 of the Constitution. Those beautiful reflections of Professor Lawrence Stride in his work, The Invisible Constitution, that, without a quote, the invisible non-textual foundation and facets of a constitution, he says, the constitution will have its working challenges, and so the visible constitution necessarily floats in a vast and deep and crucially invisible ocean of ideas, propositions, recovered memories, and imagined experiences that the Constitution as a whole puts us in a position to glimpse and quote. Professional claims are properly rooted in its written text and toward debates over what the Constitution does. To whether claims made in its reign rightly describe the content, both written and unwritten, of our fundamental law. Quote. We can find the echo of these when Justice Iyer remarked that liberty is what liberty does, and also said we must look at the deha and the dehi of a law to arrive at a workable conclusion. Justice Iyer was arrived at the thought that legal inference cannot follow purely formal logic in all cases, and the pursuit of one right answer may not be an objective pursuit. Professor H.L.A. Hart was in the same wavelength when he said that in hard cases, where the interpretation of a legal concept falls within the penumbra, deductive logic or deductive reasoning are not sufficient. I take the liberty of picking again from Justice Matthew's lecture referred to above, dealing with the challenging issues of assertion of facts and modern scientific realism. He says, quote, The methods by which truth is attained are not always the same. Natural law cannot be proved by employing the method of scientific realism. The existence of natural law cannot be proved or verified by sense data, sense observation, and quantitative experiments. The broader view of truth situation is expressed by William James in a letter to Professor Loba, and he quotes the letter. I find it preposterous that there be a feeling of unseen reality shared by a large number of men in their best moments, responded to by others, men in their deepest moments, good to live by. Strength-giving, I find it preposterous to suppose that the goodness of that feeling for living purpose should be held to carry no objective significance, and especially preposterous if it combines harmoniously with our otherwise grounded philosophy of objective truth. And quote. Principles and thoughts good for statutory interpretation need not necessarily be good for constitutional readings. When it comes to constitutional readings, we no longer talk about the mere gap-filling outer limits of judicial lawmaking. From being a correcting draftsperson dealing with textual changes of statute law, the Constitutional Court judge has now become a co-partner in the articulation of what is good or what is one right answer among the many, and what deleterious impacts on citizens' rights are perceivable differently from the position of governance institutions. The sprawling literature on this subject demonstrates the need for a paradigm shift. Did Desai perceive this global constitutional motions? I can venture to say yes. He positioned himself between being a pure Montesquieu and a constitutional course of deliberators. The concern, however, is that any radical alteration of the rules of governance may not usher in disguised anarchism or subtle frictions wearing rule of law symbols. I am making this very strong statement aligned to the need for a new theory of courts without dissolving the separation of powers, howsoever articulated, beyond which we were yet to discover any new constellation of principles in the expanding universe of human life. We need to be also alive to what Francis Fukuyama talks about liberalism under discontent, or what Thomas Piketty recently talks about rethinking socialism. The perennial values of the Indian Constitution, as we noticed above, under wise management, we hope, should provide us with the maturity to avoid pitfalls and precipices. I end my talk with you today. Probably it will be of some interest of me to read when Desai was conferred a doctorate degree from the National Law School of India University. I read the last paragraph of the citation and end my talk today. It is difficult to comprehend in this brief citation the varied accomplishments of the man who gave Indian jurisprudence a people-oriented vision and put the judiciary in the center stage of constitutional politics. Suffice it to say that there is no Indian judge till date, living or dead, on whom two doctoral theses have been written by scholars in two different universities. In this Krishna Iyer has the distinction in honoring so-and-so that the luminary and popular leader of the National Law School of India University is in fact reflect the sentiments of admiration and aspect of the Indian entire legal community to a good judge and humanist the century has produced. I end my talk with you today. I am grateful to the organizers for calling me again, and I am indeed delighted to have the two honorable judges here and the Chief Justice of Gujarat invitation. Thank you so much.
Thank you, sir. Thank you for that insightful address. Honorable Mr. Justice P.S.Narasimha, Judge, Supreme Court of India. After an enviable stint as a lawyer in the Supreme Court, where notably he was amicus curiae and later mediator in BCCI cases, law officer in the NJAC case before the Constitutional Bench, and amicus curiae for the Forest Bench, His Lordship was appointed as the Additional Solicitor General in the year 2014. With the proud distinction of having represented India before International Tribunal for the Law of the Sea in Hamburg, Court of Arbitration in Hague, His Lordship became the 9th judge to be elevated as a judge of the Honorable Supreme Court of India from the bar. May I invite our Chief Guest, Honorable Mr. Justice P.S. Narasimha, to address the audience gathering.
Chief Justice A.J. Desai, then Attorney General, Justice K.M.Joseph, to whom I am very grateful, because my life as a judge commenced when I started sitting with him. Under his guidance, that I have learned the life of a judge. He was patient with me. He guided me from time to time. He also gave me opportunities at the beginning itself. And when I was as a lawyer, senior counsel in the Supreme Court, doing only the high-end cases, and when I sat with him and as a bench partner, we started looking into matters as small as pension not being given for a period of 10-15 years. I was a little surprised that these kind of matters are still there, because senior advocate gets completely cut off from the realities. I am ever grateful to him for having brought me back to reality and enabled me to put in and focus on such minute and more important issues. Justice Balakrishnan Nair, my friend S.Narasimha Ramakrishnan, the guests of the Honorable Chief Justice, Chaya, Vaishnav, and other judges, senior advocates of this bar, members of the Sharda Krishna Sadgamaya Foundation, the registry, press, ladies and gentlemen. Nothing really remains for me after the learned attorney's erudite speech on Justice Krishna Iyer. He has covered all aspects of the matter. Perennial Justice Krishna Iyer, I would definitely say this, has transcended religion. He has also transcended region. When we speak about perennial values, not invented, very correctly, discovered as it states, I think there is something which Justice Krishna Iyer's abilities got connected with, to be connected with Kerala. Krishna Iyer is the product of the cultural and social milieu of Kerala, and we cannot forget that. Kerala, throughout the course of history, has been a fertile ground for spiritual masters, intellectual trailblazers, and social reformers. This mix is the mix of cultures gives rise to what I can say as a universal spirit. It is a melting point of all cultures. A feature of this was also indicated to me by the Honorable Chief Justice, as he said, what a pleasant surprise to be as a chief in this court, to see the beautiful mix of, from all cultures, from all religions, actively participating and contributing. Then there must be something innate in this universal spirit that we may say, which is definitely a constitutional value. It's common to use this expression that we are a universal family, Vasudhaiva Kutumbakam, as everybody keeps saying. There is something, this is of course true, but there is something which preludes that I think is far more important. It says that Udara Charitanam tu Vasudhaiva Kutumbakam, which means that those who have a history of liberality, those who have liberality in their heart, it is for them, it is from them alone that the world is one family. So it doesn't come automatically. It is something which the culture, the social milieu that brings about, where the society has that liberality in thought and idea. Another feature which is rather distinct, and all these definitely had a bearing on Krishna Iyer, which is what I believe. Kerala also has a canvas of that universal spirit, that is spiritual consciousness, beautifully integrated with social consciousness. I am only speaking on the topic that we are chosen for the day, the perennial value. I am not deviating or getting into any spiritual exposition. The pursuit of sublime, that is the spirituality, always coexisted with the pursuit of egalitarianism. The spirituality, as they said, the universal spirit, if we find in our constitution, we will find it in the preamble, that is in fraternity. Fraternity, it says, assuring the dignity of the individual. While fraternity, a deeper understanding of it, is nothing but universal spirit. And dignity is how one should treat the other. Dignity comes from that. It is the combination of these two. A philosopher close to this land was asked, "Sir, how are we to treat others?" Two-line answer was, "There are no others." There are no others. That may seem spirituality, but the essence of that idea, aspects relating to the compassion towards individuals, upliftment of the perceptions. The learned attorney has quoted some of the most remarkable quotations from his judgment. I read one introduction of Justice Krishna Iyer in an authoritative translation of Sri Narayana Guru's biography. There is a remarkable parallel one can draw from out of his judgments and what I may call as the Advaitic socialism of Sri Narayana Guru, who has so eloquently preached and practiced in Kerala. This again is a perennial value of the constitution discovered by him. As the learned attorney was saying, there are unwritten portions of the constitution which are silent. These are those silent parts of the constitution which he would have recognized and translated them in the interpretation of the constitution. It is in the work of Mr. M.K. who has written his biography on Sri Narayana Guru, that Krishna Iyer says, I have quoted it, "This tacitum wonder of Sri Narayana Guru's impact on human community is comparable to the thunderous oratory of Vivekananda." He is also a social reformer, Vivekananda. So is Narayana Guru. He compares that and he recognizes that very beautifully in his introduction, and actually he implemented it. When he was called upon to read portions of the statute law and give a correct and a proper meaning, he would say, "It is not Maxwell which should guide me. It is the perspective of Gandhi or the freedom movement which should be the basis for me to read, understand and interpret the Constitution. That is where I think he saw the perennial value and translated it for us to experience in the process of enforcement of the Constitution. It is in this very social structure and milieu in which Krishna Iyer has developed his philosophy. I would also like to mention that some of the three great ladies of our country, Kerala gave the Constituent Assembly its only Dalit woman member, Darshayani Velayudan, and also for the entirety of the Commonwealth, the first woman judge, Anna Chandi, and also the first Chief Justice of the Supreme Court, Justice Fatima Bibi. Fertile ground, therefore, it is for the judges as well as lawyers to recognize and enable youngsters to develop that attitude, develop that desire to look at the Constitution and interpret closely to that perennial value. There are only two more factors which I would indicate to you, or rather share with you. I think Krishna Iyer assiduously developed his capabilities from time to time by his unending sadhana. He would, of course, he is known to be a very hard-working lawyer, and he would, in modern terms, one would say, acquire knowledge or data, so to say. But then this knowledge was a bookish knowledge, so to say, whether they are in the form of precedents of a court in India or abroad, absolutely necessary to do so. But then they are without a face. These are all hard facts and data. But what I think he did is rather extraordinary. He subjected these facts to scrutiny and never accepted them. Looked into them deeply, tested whether they are truthful or not, or rather how close they are to truth. And in that process, I think he matched it, verified it with his experience. And what an extraordinary experience that he had. You all know about it. He was an active citizen. I underline that expression. All of us are citizens. But he was an active citizen. He was a lawyer who had a heart and would look at the difficulties of a client, and even as a lawyer, the basic essence that he had continued even when he was a judge. He was a counselor, he was a legislator, he was in the political executive, he was in the law commission. These experiences that he had, which are invaluable, were used by him to go closer and closer to truth. Simple statements of fact, either in the form of precedents or statutory provisions, were not sufficient for him to conclude and accept them as it is. So he would test them, examine them, and work practically towards arriving what he thinks is the fact, is actually the truth. That process is one of the most important facets of his life, and that samadhyam, I would say, that ability or capability is extraordinary, and unless and until the material fact and data is matched with actual real experience of life, we are far away from truth. The second aspect is equally important because that's the frailty of human life. Even if you know the truth, still we are sometimes not capable of acting towards it. Human vulnerabilities as they are yet again human. Whatever may be the factor which will force you to not accept and act according to truth. There are only those who would have again, by their sadhana, developed step by step, brought in character into their living, and by sheer power of the will would have enabled them to take that step necessary to recognize and act towards truth. This is yet another feature of Justice Krishna Iyer, and also at the same time something of perennial value to us. He acted in furtherance of the truth and for which he had the courage. Sometimes, however knowledgeable a person is, if that one small step towards acting on the basis of what is perceived to be truth is not taken, he would just leave it at that. He is a good speaker, matter ends there, nothing more. But if one is not able to articulate so very well, formulate so very well, may not have that much of knowledge, but then one strong step towards what someone thinks is truthful is definitely a guiding factor. This combination of samadhyam and sahasa, the capability and courage, is an extraordinary combination of Justice Krishna. And I think every lawyer, every person, every citizen, every individual must imbibe that. And these are eternal values not confined only to legal profession. With these I thank the foundation for giving me this opportunity. And I am also very, very happy to be amongst you. Thank you.
K.M.Joseph, former Judge, Supreme Court of India, and patron Sharada Krishna Satgamaya Foundation for Law and Justice. His Lordship's epitomizes the adage, judges speak through their judgments. His Lordship's judicial temperament, erudition, empathy, and wisdom is reflected in his epoch-making judgments. May I invite Honorable Mr. Justice K.M.Joseph for the commemoration address.
President of the meeting, Chief Justice Desai, Justice S.Narasimha, my good friend, and thank you for the nice thing you said about me. And I think I can very safely rest. A great deal of my hope and expectation of the Supreme Court is based on your presence in the court there and what I expect in the coming years. We learned that our General, who delivered a very erudite, learned and illuminating lecture, which shows his great scholarship. My Guru, Balakrishnan, I call him my Guru because he's told me, guided me when I was wrestling in this court before that. And I am eternally obliged to Sanand. Both of whom, along with T.V. Ramakrishnan, who are the real patrons. I have been a namesake patron. And just an aside, actually, I got a video over WhatsApp. There is a chap in Japan who was working and he wouldn't do any work. So naturally he was thrown out. So he tried to make capital out of it. So he advertised on Twitter that you need the service of anyone who does not do anything. Particularly during COVID time, he got a lot of inquiries, and today he's earning something like close to 5,000 rupees an hour. And he's got about 4,000 clients who are queuing him. including just seeing him off at the railway station. So I am somewhat like that, a patron. I asked Balakrishnan, what is it that you expect? No, just put your name. So that's about all. The real work has been done by T.V. Ramesh. This is T.V. Ramesh sitting in your midst, and Sanand, this is Balakrishnan. Sitting and retired judges of the High Court, both Gujarat and of Kerala High Court. I see this is Raman, Devan Ravendran and others. Senior advocates, very familiar faces, and ladies and gentlemen. Nearly 43 years have passed since Justice Krishna Iyer has remitted office. And about how many years? More than a century, obviously, because he was born in 1915. Why we gathered here? I mean, what is it that the flame of his memory? Why do you want to keep it alive and eternal? What has he done so much? Why is he unique? What did he bring to the table in his many multifaceted activities that is interesting? A little bit of delving into the past maybe necessary. He was born in pre-independence British India in the form of Balga to Krishna Iyer and Narayana Amma. Rama Iyer was himself a very distinguished lawyer, and not unnaturally studied law from the Madras Law College. And even at that time, even as a student, I believe he was deeply humanist, a value which he would persevere in throughout his life. He joined the chamber of his father in 1938 because his father was practicing in Talasheri, which is also part of British India. He came to be arrested and sent to jail on the charge, trumped up as it was, of assisting communists. He spent some time in jail, which again was to prove of great help in what he did later. In 1952, he stood for election, he was elected as an independent. Again, he was elected in 1956, he became a minister, holding as many as 5 portfolios, which included law and prisons. In both these, under these portfolios, he made seminal contributions in terms of setting up courts, bringing about schemes for the benefit of the prisoners. Here you just see the connection because the fact of his incarceration. He knew what life in jail was actually firsthand. He didn't have to rely on anything else. Thereafter, after the communist government was booted out by the central government, he resumed practice in 1959. He became a top-flight lawyer. So he went on and then finally was elevated in 1968. Became a member of the Central Law Commission. And in the space of 5 years, in July 1973, he was elevated to the Supreme Court. There he remained for 7 years and 4 months, when he retired in November 1980. For the space of 7 years and 4 months, he has left behind a body of 700 judgments. They are not just half paragraph or one line or one page judgment, are all very elaborate discussions of the law and the facts. It's incredible that you could do that. I remember saying this earlier also. Justice Holmes, who was judge of the US Supreme Court for about 29 years, he left behind about 929 judgments. Compare that with what this is Iyer achieved. He was prolific, absolutely prolific. Now he retired in 1980. And then one would have thought that he would call it quits. Far from it. He went into public life, refused arbitration, refused to do legal consultation, and he became what S.Narasimha in his book describes as the Chief Justice of the People's Court, which he indeed was. The doors of his house would be thrown open to the most underprivileged, the poor, those in need, obviously without charging anything. And this is something which he continued to do right till the very end, which is a long period of life, that is 99 years. He died at the age of 99. Throughout he raised his voice. What he did when he was a judge, he was consistent and he was fearless. Why I say he was fearless? He was hauled up for contempt of the court I had a little role because I was an amicus in that case. So, of course, it was dropped because they knew that Krishna Iyer was at heart having the best interest of the judiciary. And his criticism was directed to cleansing the system, to make it really a public, a medium for the administration of justice in the best sense. Now, having said all this, I'd like just to dwell for a few minutes because I know Mr. Narasimha has to catch a flight at 3 o'clock. The attorney also has to be flying to, I think, in Chennai. So I'll be brief. Because otherwise we can speak on days about Krishna. So what are the qualities that he brought to bear? Most of his judgments, his speeches, they are literally gems. His language, of course, was under criticism. Sirwai was very emphatic about his criticism, but later Sirwai turned around in his later editions to lavishly praise him for his contributions in the field, in various branches of law. Now, the first thing is this, passion for knowledge. Because, knowledge doesn't come upon a judge overnight. The moment he is elevated, one fine morning you suddenly want to master the law. It's not possible. So where did it start? It started, he gives an interview in which he says that when he was a lawyer, young lawyer, he would get articles mostly about socialism from Madras. Now he would gobble it up, read everything that was possible, at that time when he was young. He didn't think of becoming a Supreme Court judge, I remember the law commission. So it's a lifetime of study. And what all did he read? He read not just law, he read politics, he read philosophy, he read sociology, history, literature. Because if you see his judgments, if you see his speeches, if you see his essays, you will see copious references to like Emerson, Anatole France, to Keats, to the Aurobindo Ghosh. In fact, he delivered the Tagore Memorial Lecture on human rights. It's a beautiful book you will get. In the first chapter, which is under the title Be Profoundist, he says, who am I? And he says that he follows the principle of Tattvamasi. It allows you to be infinite, part of the infinite. And there are no limitations except that you put on yourself. And the saint and the pariah come from the infinite. It is from that principle that he draws the conclusion that the constitutional principle of equality is also reconcilable with the Vedantic principle that all of us are one. We are part of the same divinity. If this is all the time, you must realize that everybody was not religious. He was secular. He was completely secular. In the aftermath of the riots in Gujarat, I believe he went about along with some other judges to conduct some kind of an inquiry on his own. He was a socialist at heart. I was in fact just wondering, today we have the IBC, the Insolvency and Bankruptcy Court. Under the provisions of the IBC, what are the things which stand out is that once a resolution plan is approved, the government debts do not have any special place. Once the debt is, whatever is possible under the resolution plan, so that you revive a company which has gone under the gun, it is binding on the government. Because there are some cases pending in the Supreme Court relating to the nuances of it. What I am saying is that once a resolution plan is approved to revive the company, which is the first priority under the Act, thousands of crores of government debt may get swiped under the carpet. I don't know how Justice Iyer, if he were alive, would have reacted to that. I do not know if Justice Iyer came back to this world today, how he would have thought about, what he would have thought about the disinvestment of public sector companies. I am not saying, I am not pronouncing on, not giving my value judgment. I am only saying, knowing Justice Iyer through his judgments and speeches, I wonder how he could have reacted, and he would have reacted strongly, independently, spoken out from any forum, which is why he was in fact nearly called of a contempt. That was a man, that he was absolutely fearless. Now, being fearless does not, however, mean that when he was a judge of the court, right in the Kerala High Court and 7 years in the Supreme Court, that he ever wrote a judgment without the juristic underpinnings being solid. He never pandered to the public. He was not a populist judge. As a judge, he was very conservative in terms of legal theory, which had to accompany his findings and conclusions. He was very, very clear about it. He was very patient as a judge. People would have thought that, in fact, when he was his name was proposed to be elevated to the Supreme Court, I think somebody in the Bombay High Court said a complaint against his being elevated. That here is a communist, what are you going to do? You will ruin the country. He proved everybody wrong. Because as a judge, while he was a constitutionalist, while he had imbibed all the values of the Constitution and brought it to bear on each of his judgments, he never actually wrote a judgment without there being solid juristic legal foundation. That is one of the greatest things which I have learned about. He would have, I was just wondering, today 1% of the Indian population owns about roughly 60 to 70% of the nation's wealth. I will wonder how today, because he was always a socialist and a humanist, how he would have reacted, what he would have said. I am sure he wouldn't have remained silent. So whatever, I am not judging what is happening today is right or not. I was wondering, knowing him as I do, I had the great honor of sharing a stage with him in a matter. And also, because of my relationship with my father, I had seen him in physical person. And one last thing, and I am done. In 1974, something happened in his life, which perhaps laid the foundation for what he did and why he did it. He lost his wife to cancer, to a heart attack. They were soulmates. He has written a book about it, appearing in Presided. He was left a lonely person. He was left because he had 2 sons by nation, the other, and one of them employed abroad. And the other was a lawyer, but he didn't into practice. So he's alone, practically alone. He devoted his entire life to the whole world. He, actually he channelized his personal suffering for attaining the good of the whole world. Because from that moment onwards, when he decided to do that, he was not alone. He belonged to the whole world, and rightfully so for all that he has done. Thank you so much for your patient hearing.
We'll be soon moving on to the award distribution ceremony. May I request all the award winners, the first rank holders of LLM and LLB programs from different universities in Kerala, to kindly come over to the right side of the auditorium. As a token of our deepest gratitude and appreciation, we'll be presenting mementos to our honorable dignitaries. May I invite Advocate N. Manoj Kumar, State Attorney, to come on to the dais and present a memento to Honorable Mr. Justice S.Narasimha as a symbol of our heartfelt appreciation and gratitude. Request Advocate P.B. Sahasranaman, Vice President, Krishna Foundation for Law and Justice, to come forward and present a memento to Honorable Mr. Justice A.J. Desai, Honorable Chief Justice of Kerala. May I request Advocate Lakshmi Narayanan, Trustee, Krishna Foundation for Law and Justice, to present a memento to Honorable Mr. R. Venkataramani, Attorney General for India. Now we'll be moving on to the award distribution ceremony. We'll be presenting Justice Krishna Iyer Merit Awards for first rank holders in LLM and LLB batches from different universities in Kerala. May I request Honorable Mr. Justice S.Narasimha to do the honors. We'll be presenting the award to LLM batch first. May I invite Mr. Srihari B.S., first rank holder in LLM for the year 2021 to 23 from Central University of Kerala. Ms. Niyata Rajiv, first rank holder in LLM for the year 2020 to 22 from Mahatma Gandhi University. Mr. Nikhil Vishwa, first rank holder in LLM, batch 2022 to 23 from Kochi University of Science and Technology. Ms. Anjana S, first rank holder in LLM, batch 2021 to 22 from Kochi University of Science and Technology. Ms. Reshma Tia, first rank holder in LLM, March 2022 batch from University of Calicut. Ms. Kavya K.M, first rank holder in LLM, December 2022 batch from University of Calicut. In her absence, her sister will be collecting the award on her behalf. Ms. Judy Ann Thomas's sister on dais. Ms. Amila Raji, first rank holder in LLM, batch 2022 to 23 from University of Kerala. Ms. Swati Jairaj, first rank holder in LLM, batch 2020 to 22 from Kerala University of Fisheries and Oceanic Studies. Next, we will be presenting awards to the first rank holders in LLB from different universities in Kerala. May I request our Honorable Attorney General to do the honors. Our Honorable Attorney General, Mr. R. Venkataramani, will be distributing the award to the first rank holders in LLB. Ms. Ganga Shankar, first rank holder from Mahatma Gandhi University in BCom LLB batch 2017 to 2022. Ms. Ganga Menon, first rank holder, BA LLB from Mahatma Gandhi University, batch 2022 to 23. Ms. Lisa Rose, first rank holder in BCom LLB 2019 to 22 from Mahatma Gandhi University. Ms. Navya Suresh, first rank holder in BBA LLB from the batch 2017 to 23 from Mahatma Gandhi University. Ms. Navya Suresh. Ms. Anjali CP, first rank holder, BA LLB, batch 2018 to 23 from Kannur University. Ms. Paurnami S, first rank holder in LLB Unitary batch 2019 to 22 from University of Calicut. Ms. Vrinda S. Kumar, first rank holder, BBA LLB Honours, batch 2022 to 23 from University of Calicut. Mr. Mohammad Shafi, first rank holder in LLB, batch 2019 to 22 from Kochi University of Science and Technology. Ms. Gauri N, first rank holder, BBA LLB, batch 2018 to 23 from Kochi University of Science and Technology. Ms. B. Niranjana Babu, first rank holder in BCom LLB Honours, batch 2018 to 23 from Kochi University of Science and Technology. Ms. Neha Maria Anthony, First time holder, BA LLB Honours, batch 2018 to 23 from National University of Advanced Legal Studies. Congratulations to all the award winners and thank you honorable dignitaries for doing the honours.
Ladies and gentlemen, in this distinguished gathering, it brings me immense joy to acknowledge the gracious presence of Justice Narasimha, Honorable Judge, Supreme Court of India, who, in his characteristically serene and thoughtful manner, has delivered an impromptu, insightful address in a compelling way, with clear emphasis on the enduring values of constitutional law as brilliantly elucidated by Justice Krishna Iyer. On behalf of the Board of Trustees of the Foundation and personally, I extend heartfelt thanks to Justice Narasimha for gracing the occasion as our chief guest. Your charismatic presence combined with your inspiring address have helped enlighten this gathering with a deeper perspective and a broader understanding of the key topic of this event. Thank you, sir. The 9th Justice V.R. Krishna Iyer Memorial Law Lecture on the topic Perennial Values of Constitutional Law, discovered by Justice V.R. Krishna Iyer, has been prepared meticulously and has been delivered with masterful eloquence and erudition by Sri R. Venkataramani, Attorney General for India. The topic chosen by Sri R. Venkataramani is a fitting tribute to the legendary Justice V.R. Krishna Iyer. Our sincere gratitude to Sri R. Venkataramani for taking time out from his compellingly hectic schedule to spare a few moments with us. With profound wisdom and erudition in every insight that has been so beautifully articulated, we are now more enriched in our understanding of the profound values upheld by Justice Krishna Iyer. Thank you, sir. Today's occasion is even more special as Sir is joined by his wife, Sri Vijayalakshmi Venkataramani. We feel doubly blessed to have your gracious presence on this occasion. Thank you so much. I extend my heartfelt gratitude to Honorable Mr. Justice Ashish Jitendra Desai, Chief Justice of the High Court of Kerala, who readily agreed to preside over the function. Your guidance as the Patriarch of the courts in Kerala have been invaluable in steering us in the right direction with regard to today's function. We express our deepest gratitude for your esteemed presence and for making this occasion a truly memorable one. Thank you very much, sir. A special thanks to Honorable Mr. Justice K.M.Joseph, former Judge, Supreme Court of India, for graciously agreeing to be our patron and for delivering the commemoration address with characteristic flair, grace, and valuable insights. Your illustrious presence has added immense value to the function. Thank you, sir. We also extend our warmest and heartfelt gratitude to the distinguished guests, Honorable Justice R.M. Chaya, Honorable Mr. Justice Ashutosh Shastri, and Honorable Mr. Justice Viren Vaishnav, who especially come from the High Court of Gujarat to grace us with their presence. Thank you, sir. I am also thankful for the presence of Honorable Mr. Justice Deven Ramachandran, Honorable Mr. Justice Dinesh Kumar Singh, and Honorable Mr. Justice V.G. Arun for their presence today. I also thank the members of the Board of Trustees, particularly Justice T.V. Ramakrishnan, Chief Patron, Justice K. Balakrishnan Nair, President, Sri V.V. Siddharthan, Senior Advocate, P.V. Sahasranaman Sir, Sri R. Lakshmi Narayan Sir, Dr. K.P. Pradeep, and our Chief Executive Officer, Srimati Chandrika Arvindakshi. Your wholehearted efforts have been instrumental in the seamless organization of this function. A special word of thanks is also due to Sri P. Krishna Kumar, Honorable Registrar General of the Kerala High Court, Sri T.S. Arun, Public Relations Officer, and Sri Robin, IT Cell in charge, for their wholehearted cooperation, without which this function could not have taken place smoothly. I would also like to express appreciation for our dedicated young volunteers, Advocate Pasmi Taj, Atira Menon, Anjana Kannan, Govind, and our compeer, Ms. Krishna, for their commendable efforts in facilitating the event. Marking our humblest tribute to an iconic and legendary personality, I extend my sincere thanks to all of you. This expression of gratitude is not just a formality, but a humble offering, a Guru Dakshina, in honor of my father's Guru, Justice V.R. Krishna Iyer. Thank you.
Last to kindly come out to the dais for a group photo with the honorable dignitaries. May I also request the presence of Honorable Mr. Justice David Ramachandran and Honorable Mr. Justice
जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जगति तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगल दायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे.
We have come to the end of the ceremony. Once again, thank you one and all.